Welcome to episode 22 of the Extremely Non-Extreme podcast. I am the host, Quentin Whitrock. Recent episodes have been exploring a series of 10 policy statements that I have set forth in this political podcast. And today's relates to the topic of crime and law enforcement. To discuss this policy today, I have with me Brad Johnson, Anoka County attorney. Anoka County is a county in Minnesota, which is today part of the suburbs of Minneapolis. And the policy statement I'll be discussing with Brad is there is too much crime in America, and law enforcement personnel must be empowered to fight it forcefully. Brad, where does a county attorney's office fit into the crime and law enforcement picture?
Happy to talk about this. Good morning to you, Quentin. I think it might be helpful for your viewers to know that you and I have a little bit of a history too. So,
Hey.
When I started practicing law some time ago, it seems like a long time ago. I went to work in a law firm where you were a partner, and so I worked with you a long time ago. I don't normally do podcasts, so I appreciate the opportunity, and I certainly enjoy talking to you about stuff like this.
Well, you're doing a great job as county attorney. You're making all of us that knew you way back at the law firm, you're making us proud. So tell us about law enforcement and what the county attorney's office does.
Sure. For your viewers, it might be helpful for them to understand that Anoka County is about 375,000 people ballpark. That's kind of the size of the county. We're the third largest county.
Let me interrupt you, Brad. I believe that's 5% of the population of the entire state of Minnesota.
Yeah, and we have 87 counties, but Anoka County is one of the big ones. Yeah. Our office is the third largest county attorney's office in Minnesota. We're very close in size to Dakota County and the Dakota County Attorney's Office. We're on the northern side of the cities. They're on the southern side of the cities. And then, of course, there are the two urban county attorney's offices in Hennepin and Ramsey counties. We have about 50 attorneys. We have a total staff, including the attorneys, of about 120. There are 27 cities ballpark in Anoka County. And the role of the county attorney, especially in a county of our size, where we're heavily populated with cities rather than cities and townships, and there's a difference, is to focus on all felony and juvenile crime in the county. So we wear one hat as the chief prosecutor for all the big stuff and the stuff that relates to the kids in the law enforcement and criminal justice arena. And then the other hat that we wear is that we're the chief legal advisor for the county board and all of the county departments, whether it be HR or transportation or the libraries or property tax and records, all of that sort of stuff. And so it's a very diverse office. We have a civil division, a family law and child support division that also deals with civil commitments. We have a juvenile division that deals with both juvenile delinquency and child protection. And then, of course, we have the criminal division that deals with those major felony crimes. And so where we fit in is when law enforcement agencies around the county or in the state of Minnesota have investigated crimes and they want to submit a case to a prosecutor. They submit it if it's a felony level case, or if it's one of those cases where we are specially designated as the prosecutor, they submit it to our office. We review the charges. Sometimes we decline the case because there's not enough there to prosecute it. Sometimes we refer the case back to the agency that submitted it because it requires further investigation for us to make a prosecution decision. And sometimes we charge the case or present the case to a grand jury and we move forward with a criminal prosecution. So that's how we fit in.
Very good. Safe streets. That's
Yeah.
something I hear all the time when I'm living in my world of politics. In your world of law enforcement, what's your impression of whether we do or don't have safe streets in Anoka County, Minnesota?
Yeah. Broadly speaking, I would say Anoka County has safe streets. We're very proud of the kind of community that we have developed, and also to give your viewers a little bit of an understanding, because there are different challenges in different parts of our big county. You know, we are fairly urban to the south, suburban in the middle, and quite rural to the north. And I think for the most part, people believe that Anoka County is a safe place to live, work, eat, sleep, and play, and people enjoy living here. That does not mean we're without challenges, and certainly we as a county struggle with various different kinds of crimes. Things that are top of mind right now to me are those um, drug-related crimes, the fentanyl overdose cases, the methamphetamine cases, the situations where children are put at risk. I will say that in the last several years, the sheriff and I have both seen kind of an evolution where overall crime numbers might be down, but we're dealing less with the crime that annoys you. You know, that it used to be the drug cases, the lower level drug cases, the livability kinds of crimes where people are committing petty thefts and things like that around the community. Those numbers might be down. Where we've seen a concerning amount of crime that still continues to be front and center in our minds is on the kind of crime that scares you. I will say that in my term, and I'm in my first term as a county attorney, started in 2023, and I'll run again for office again this year. Um, we have had more murder cases in Anoka County than we have seen going back about 20 years. There was a odd year that we had way back in our past, but for example, my office and the amazing prosecutors that work with me tried to a jury 6 major felony murder cases in the last 5 months of last year. That's a lot of jury trials for a county attorney's office of any kind that just include murder cases. It's a lot for an office of our size. We won convictions on all 6 of those. They included, and I think this is important for your viewers to understand too, they included a home invasion burglary where 3 individuals were posing as UPS delivery people. And they came in and they murdered a family in front of their children. I'm glad to say that following those 3 jury trials, those 3 individuals are going to be serving life sentences without the possibility of parole. They include a young man who basically executed his ex-girlfriend right in front of her home. Won a conviction in that case, and he too has a long sentence now to serve. We have a case that involved a fentanyl overdose. That was a uniquely difficult case to prosecute because in order to prove the science behind the fentanyl overdose and the chain of custody on the handling of the testing of the blood that was involved to prove the toxicology that was necessary to secure a conviction in that case, our office had to bring, I think it was 15 experts from out of state, and it cost the taxpayers of Anoka County $100,000, give or take. And so we have leaned into getting serious consequences on these serious offenses. Now, we're always limited by what the evidence is, right? You try the case that you have, not the case that you wish you had. And so there are times where we negotiate pleas in cases. All I can tell you is that we put our best foot forward to try to keep the citizens of Anoka County safe and to secure appropriate and just consequences where we can.
What obstacles does a county attorney face, or what obstacles are there to make the streets even safer or to reduce violent crime in a area like Anoka County, Minnesota? What obstacles?
So from the standpoint of, I wouldn't say it's obstacles. I'd say it's more challenges. But from the standpoint of a county attorney's office, the challenge is to bring the various stakeholders, especially your law enforcement partners, together to focus efforts on various things. Sometimes it could be those fentanyl cases or methamphetamine cases. Sometimes it could be finding ways to quickly address the domestic violence cases. One of the things that we have done in Anoka County that is unique, and I hope at some point in time it becomes a model for the rest of the state of Minnesota, is we've created a joint law enforcement council. And what the Joint Law Enforcement Council does is it meets quarterly. The membership of the Joint Law Enforcement Council is composed of the county attorney, the sheriff, every chief of police in Anoka County, a city council member or city representative from those cities that have police departments, a couple of county commissioners, so county board members are on that. And then there are some additional ad hoc members, including our emergency communications, our fire service, that have membership on that council. One of the things that has been important in that is bringing people together. And the reason we have both electeds and appointed law enforcement on that council is so that people can understand what's going on across the county, how we can leverage our resources and share our resources together. For example, we created a very robust public safety data system. So all of our law enforcement, whether it be the police in Coon Rapids or the police in St. Francis or the police in Ramsey or the sheriff, can be in communication and share data back and forth very well on things and know about people that they've had regular contact with. That has allowed us to, I think, have better and more open channels of communication where we are sharing information about what each community is dealing with and then working together to solve those problems. So communication, as in everything, is key. And I think that's one thing we've done to address that challenge in Anoka County, among other things.
Maybe that's a good segue into the next topic I want to bring up. And I'm sure this is a topic that is still heavily on the minds of all of our listeners, not just those in Minnesota, but your experience during Operation Metro Surge. That might be the ultimate example of, shall we use the term, interaction between different federal and state actors in the law enforcement procedure. Highly controversial. And I know there were differences in county approaches to the ICE surge. And you're in Anoka County. Most of the activity was in Hennepin County, Minnesota, where Minneapolis is. But what's your perspective on Operation Metro Surge and your interaction with it in the law enforcement efforts you make?
Yeah, I mean, I have some wide and ranging thoughts on this because, in part, our experience was different than, say, Hennepin and Ramsey counties, the two urban counties in Minnesota. And I will say at the outset, I'm very empathetic to the struggles and challenges that my brothers and sisters who are county attorneys in those areas are dealing with in terms of working with or sometimes against the federal government on just getting the basic evidence they need to make the decisions to protect their own communities. Let me just say, from the standpoint of Anoka County, there was some significant ICE activity in Anoka County. It was mostly centered in the southern part of the county, although there were ICE or Border Patrol activities that happened in other parts of the county, including the more rural parts of the county as well. The thing that was disappointing to me as a county attorney is when Operation Metro Surge happened, notwithstanding all that we had done to prepare for it, and I can talk about that a little bit, the communication from the federal government to our county was poor. I'll just leave it at that, notwithstanding efforts by the county to engage. I think a lot of that was driven by the fact that we were not dealing as much with our local ICE counterparts as we were encountering various different teams that were brought in from other parts of the county that candidly were working in Anoka County and throughout parts of Minnesota with very little supervision, especially very little supervision from the local ICE agency where we had established relationships. I can tell you that back in 2024, 2025, because of the Joint Law Enforcement Council and how our chiefs and sheriff worked together, we had reached out proactively to the local ICE office, the field office in St. Paul, and invited them to come to Anoka County so that we could have a conversation about how things could and ought to happen if anything moves forward in Minnesota that was along the lines of surges we'd seen in other parts of the country. And I thought we had a fairly good understanding and a good expectation on communication. We expressed a concern that we be kept informed about things because we wanted to avoid situations where, due to a lack of communication, there might be sometimes it's called a blue on blue incident, where ICE is doing one thing and our law enforcement doesn't know they're doing it, and the public is concerned and they call in, and then there's conflict between agencies and a lack of sharing of information. Thankfully, that didn't happen, although there were instances where our law enforcement was deployed out because of calls from the public, and I think legitimate calls from the public that they were concerned about some activity in their neighborhood or directly impacting them, and our law enforcement was going in blind. Now, fortunately, they handled that situation, I think, well, but the communication was poor. I will tell you one particular example, and it does reflect a difference on how our county approaches things and maybe how other counties approach things. I mean, we had a situation in 2025. This is just before, or a bit before Operation Metro Surge, where our office was involved in prosecuting a criminal case. It happened to be a criminal sexual conduct case, so a rape case. The victim was, at the time of the offense that was alleged, a teenager. By the time of the trial, where we were having a court hearing, the victim was a young adult. Our office had worked for over a year to get that case ready for trial. They were on the first day of the trial where they were going through pretrial motions, and during a period of time on that hearing day, ICE officers came into our courthouse and literally took the defendant away into federal custody without communicating with our office or local law enforcement at all. My prosecutors were left without a case that they could prosecute at that point in time. The defendant wasn't there to have their day in court. The victim couldn't have her day in court. And that was upsetting to our office. Instead of making a social media splash about it or putting out a press release, the way I approached that was to reach out to the local ICE office and explain the situation to them, talk through their concerns, our concerns, tell them where we were at in the process, and request that they cooperate with us to return that defendant back to our courthouse so that we could have that trial. We did work with them, and we had the trial. And the criminal justice system did what the criminal justice system did. We had a jury trial on it. And after the jury reviewed all the evidence, they acquitted the defendant in that case. He was then returned back to ICE custody. And we worked through that matter by having good relationships. I'm aware of situations in other counties where people have been taken from courthouses and they've had trials that were ready to go. And when I've asked ICE in our local field office about whether those counties reached out to try to get them back like we did through an agreement and through court orders, the answer was no. And so, you know, I think everybody has to recognize that public safety benefits and values and the legitimately of properly coordinated federal and local stuff is still possible, even in difficult environments. We need to, I think, improve, especially with the federal government, how we define operational requirements when we're doing surges like this. Like, one thing I would recommend is that community trust and human rights have to be part of the operational requirements in any operation, including the one like Operation Metro Surge. I think we were very clear with the local ICE office that certain things happening in our county would not be tolerated is too strong, but would be scrutinized. And that includes things like entering houses without a judicial warrant. That includes things like taking children when it's not necessary or failing to cross-report to our child protection agencies. I will say one of the things that happened in Anoka County that I leaned into pretty hard, in fact, asked ICE to come visit with us in our office to talk about it, is we had in one of our southern cities 7 or 8 children that were taken, sometimes with parents, sometimes without. And part of the role and responsibility as the county attorney is child protection. And that is a role I take very heavily. In the time leading up to Operation Metro Surge, we thought we had an understanding with the local ICE office that they would cross-report to our child protection. So if children needed to be detained, they wouldn't be taken into custody, that they would cross-report to child protection, and we would then find an appropriate placement for those children as the federal government then worked through whatever immigration process they needed to do. I know some people are aware of a little boy named Liam in Columbia Heights that was taken with his father. And we talked to ICE about that situation.
For those who don't know, Columbia Heights is in Anoka County.
Yeah, Columbia Heights is in southern Anoka County. And what came out of that conversation with ICE was an understanding, I would say, as to a recommended protocol. So what we have encouraged them to do, and what they have expressed in openness and willingness to do, although I think we still have to work out the finer points of it and how it all actually will be deployed in the future, is that when a child is implicated in an immigration enforcement action, and that could mean that they are stopped with a parent, or perhaps they're taking a parent and they know a child is in school and a child is going to come home to an empty home, that the immigration enforcement officers, whether it be ICE or Border Patrol, would make a call to our emergency communications and ask for a courtesy response from a local agency, and then say, here's what we need, and here's what's going on. And then the local agency will assist in cross-reporting to our child protection unit. And then our child protection unit will come out, social workers will come out and take a look at the matter and see if we can appropriately and safely place the child either with relatives first or with kin, or with an appropriate foster family. Well, the other family members are appropriately being dealt with by the federal government in whatever manner they need. The idea is that no child that has a home and is in school in this community needs to go into custody just because of their immigration circumstance. That's the idea that we've put forward to them. Now, the situation is different down on a border, where Border Patrol might come across a family that's crossing a border and they don't have a home and the child isn't enrolled in school. That's not the situation we have here in Anoka County. And candidly, the federal government needs to work with us to recognize those differences and then also work with us in a way so we can protect the health, safety, and well-being of children, because candidly, they haven't done anything wrong. So those are some differences.
Very interesting. Very, very interesting. Thank you for relating that experience to us. And I'm sure that'll help people understand that it's not quite as all right and all wrong what went on there, depending on your perspective. I have a different kind of a question. I was an attorney, as you mentioned, and I would have a client. You are an attorney, and you must have a client. Who is your client?
Yeah, so that's an interesting and nuanced question, and sometimes I think the public doesn't quite understand the role of the county attorney. So this is a good opportunity for me to help people understand it. Remember, I talked about the two hats. In the prosecution side, I stand in the shoes of the state of Minnesota. So me, Brad Johnson, the county attorney in Anoka County, and all the assistant county attorneys that are prosecutors under me, we represent the interests of the state of Minnesota in court in criminal matters. On the civil side, when I'm wearing the civil hat, my role and the role of the assistant county attorneys who work with me on the civil side, we represent Anoka County as a body politic. So we are not the personal attorneys for the county commissioners. We are not the attorneys, strictly speaking, for the county board, although the county board also represents Anoka County as a body politic. My role is to be independently elected to assure that we're giving the best possible legal advice and service to Anoka County as a body politic. And that means that when the county administrator asks for advice on a matter, we shall give it. When a department head asks for advice on a matter, we shall give it. And when the county needs representation in court, it's our obligation to work with and divine from the county board what their goals and objectives are, and then to represent those interests in court. We are, though, I am independently elected, and we have to look out always for the best interests of the county. And sometimes that means that the role of the county attorney is to caution other electeds around the county or other agencies about where their legal limits are. Sometimes I have to advise the county board that the thing that they want to do is not the right way to do it, or might run into conflict with various laws, and encourage them to take a different path. So there is an independence to the role of county attorney.
I want to try to analogize, and I don't know if this is a situation that can be analogized, but there is also something called the United States Department of Justice, the DOJ. Used to have a head by the name of Pam Bondi. no longer head of the U.S. Department of Justice, the Attorney General. Is that, who's the client of that law firm, the U.S. Department of Justice? Is it the President of the United States, the U.S. Congress? Whose client? Who is their client?
That's an interesting question because I think, as you and I were trained as lawyers and we came up in the system, I think we were trained and we have a general understanding of what the role of a federal prosecutor or a United States attorney or the attorney general is. And then there is current politics where there is pressure being applied to that role in an effort to kind of redefine that role. The Attorney General of the United States of America is supposed to be in a similar position to me, although they are appointed and not elected. And so the executive branch, the president, and those members, leadership members in the executive branch, have a heavy influence on the role of the Attorney General, and then the role of the Attorney General as a heavy influence on all the United States attorneys around the United States in the various districts who are subordinate to the Attorney General. One thing that would be really interesting for your viewers, I think, to read, and it's not a big read, but is a speech that former Associate Justice of the United States Supreme Court, Robert Jackson, wrote when he was the Attorney General of the United States of America way back, decades and decades ago. And Robert Jackson is a really interesting individual in our history because he literally took the role of Associate Justice and then following World War II, went and was one of the chief prosecutors at the Nuremberg trials, often called the Nazi trials, those war crimes trials. But he was a super intelligent individual in our history, and he wrote a speech to all the U.S. attorneys around the United States called the Federal Prosecutor. And I actually pulled it up here and I have it in front of me. And I'd like to just read a couple of excerpts for you because I think it helps frame a response to your question. It begins with this statement. It would probably be within the range of that exaggeration permitted in Washington to say that assembled in this room is one of the most powerful peacetime forces known to our country. Just as an aside, assembled in the room were federal prosecutors. The prosecutor has more control over life, liberty, and reputation than any other person in America. His, and I would say his or her, discretion is tremendous. And then I skip down to the bottom of that paragraph and it says, well, the prosecutor at his best is one of the most beneficent forces in our society. When he acts from malice or other base motives, he is one of the worst. It goes on, and this is an important passage that I want your viewers to hear. Because of this immense power to strike at citizens, not with mere individual strength, but with all the force of government itself, the post of federal district attorney from the very beginning has been safeguarded by presidential appointment, requiring confirmation of the Senate of the United States. You are thus required to win an expression of confidence in your character by both the legislative and executive branches of government before assuming the responsibilities of a federal prosecutor. Your responsibility in your several districts for law enforcement and for its methods cannot be wholly surrendered to Washington. I'm going to say that again. Your responsibility in your several districts for law enforcement and for its methods cannot be wholly surrendered to Washington and ought not to be assumed by a centralized Department of Justice. It is an unusual and rare instance in which the local district attorney should be superseded in the handling of litigation, except where he requires the help of Washington. In other words, later Justice Jackson, as Attorney General, was saying, you all in the local districts are responsible for law enforcement and prosecution in your localities, and you determine the priorities and the needs of your own district, and you are trusted because of your high character to make independent decisions that you don't wholly surrender to Washington. In the final paragraph of this speech, which I really commend it to your readers to read because I draw upon it as guidance from time to time. He wrote, "The qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman. And those who need to be told would not understand it anyway. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power. And the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth, not victims, who serves the law and not factional purposes, and who approaches his task with humility." That's what the role is supposed to be. So when you reflect upon the actions of attorney generals and United States attorneys and federal prosecutors, I implore your listeners and people who read this to reach back to these guiding principles, because I think this is the best statement on what the role of a federal prosecutor should be. And candidly, it's a great statement for us local prosecutors too.
That's great. Thank you for having that available to enlighten us with. So the last topic I want to bring up is sort of the opposite of prosecuting, and that is pardoning. And I don't know if this has ever happened to you, but I imagine whether it has or hasn't, you can empathize with the prosecutor who has prosecuted, obtained a conviction of a defendant, sees that person go to jail, maybe for a long time, and then a pardon is issued. What does that do to a prosecutor, and what are your views on pardons of convicted criminals?
So the way that I think about the pardon process, which is a constitutional process, so it is part of our rule of law, right? It's a constitutional process both at the federal level and at the state level, is that the pardon process is an extraordinary power. Okay, that's the way I look at it, and that's the way I define it. I think this is my view and my perspective, it should be used sparingly, and it should be used with a process, so that the person that is issuing the pardon is fully informed, has had a meaningful opportunity to examine the record and to determine and weigh the balance between public safety and the interest of justice. Wholesale pardons of people are detrimental to both the rule of law and are detrimental to the public's confidence in a criminal justice system, because the public can see that there was little process. And drawing back upon some of the statements of Justice Jackson, that the pardon maybe was used for factional purposes or political purposes rather than for protecting the community or serving the interest of justice. It can be viewed and has been viewed, especially at the end of presidential terms when pardons are issued, um, kind of almost at the 11th hour or midnight kind of pardons before somebody leaves office. It can be viewed as an abuse of power. And sometimes I think it's appropriately viewed as an abuse of power in those circumstances. Where it comes to me is, and I've got some of these on my desk right now, is occasionally in Minnesota, there is um, a request by an inmate for a pardon or for some form of clemency or commutation, or to be involved in some other restorative process. We have a new process in Minnesota called prosecutor initiated resentencing, which is fully within the discretion of a judge and a county attorney, but is almost never, if only rarely used. But we get these requests for pardons from time to time, and the process that has developed is for, especially in the state of Minnesota, for the governor's office through the Department of Corrections to reach out through and for the board of pardons. So it's not just the governor making decisions independently. The governor is making decisions with the advice and counsel of other professionals. They reach out to the original prosecuting agency. They reach out to, if they can find them, victims of crimes. They reach out to the local law enforcement agencies and they solicit input. And it sometimes comes to us in a form which is, I agree with the request for a pardon, I do not agree, or I'm not going to express an opinion or don't have a position on it. When those come to our office, I refer them back down to our criminal division, ask them to investigate the matter. They talk to our victim witness unit. They try to reach out to the victims of the crime and see if there's any further input. We try to do our own due diligence, and I wish the state would do a better job informing us of this stuff, of what progress has the person made while they've been incarcerated through programming. They often don't tell us much about that. We read letters of support. We read sometimes other evidence that they submit to us. Sometimes it might be from a therapist, or it might be from a community organization that has been working with an individual. And then we weigh all that and then we respond. I would say often, because of the severity of the offense, of the impact on public safety, of the concerns that we have, we oppose that. I mean, I'm a firm believer in truth in sentencing. When somebody is sentenced to life or to 20 years for a major crime, I think that's what the public expects them to serve that time. There are some situations, and I'm dealing with one right now, where you can see that the person has made great strides toward rehabilitation. And one of the things that is a goal of our criminal justice system, a robust criminal justice system, is when people go into custody, that they come out. This is a goal. I'm not saying it happens all the time. I'd like it to happen more often than it does, but they come out better than when they went in, with more resources available to them, with a better leg up, so that we don't deal with recidivism. I mean, it's kind of that simple. So reintegration and reentry are huge to us. And when people have made a good faith effort to rehabilitate themselves and they are clearly ready for reentry, on a rare occasion, we agree with the pardon or the commutation or some form of clemency. And I think that's an important part of getting people back involved in our society and our community. I would say, though, it should be used sparingly and it should be used with a process.
Excellent. That is a good stopping point, I think, for our podcast today. There's so much more we could talk about. I'd like to have you back for another episode down the road, but we better put a period on the conversation with that. But thank you, Brad Johnson, Anoka County attorney in Minnesota. You've provided us a unique insight and shared with us information that we didn't otherwise have. And that's the purpose of the Extremely Non-Extreme podcast. I think even on things like law enforcement and crime, there is a lot to be said for considering all viewpoints before rushing to judgment. And you've helped us to do that. So thank you very much, Brad. And for the rest of you who are listening, we'll look forward to our next episode. Thank you.
My pleasure. Thank you, Quentin. Thanks for the opportunity.